The Supreme Court has issued conservatory orders temporarily suspending portions of the Court of Appeal's decision declaring Finance Act 2023 unconstitutional. This decision comes in response to appeals filed by the Cabinet Secretary for National Treasury and Planning, along with 4 other government officials, against the Court of Appeal's decision. The Finance Act of 2023 suffered a major setback on July 31, 2024, when the Court of Appeal invalidated it, citing procedural flaws in its enactment, leading to widespread uncertainty about the government's financial and operational frameworks, prompting the then Treasury CS Professor Njuguna Ndung'u to seek relief from the Supreme Court. And I quote, "Taking into account the uncertainty regarding the revenue-raising measures and difficulty that may arise in the operations of the 2 levels of government as posed by the applicants, coupled with the far-reaching implications of the declaration of the entire Finance Act 2023 as unconstitutional, we are persuaded that the consolidated appeal may be rendered nugatory." Concerns about the legislative process used to enact the Finance Act dominated the Supreme Court's deliberations, particularly the level of public participation and adherence to Article 114 of the Constitution, which governs financial legislation. The court acknowledged that these issues require additional judicial scrutiny and should be thoroughly examined during the full hearing of the appeals. However, in granting the conservatory orders, the Supreme Court emphasized the importance of maintaining government stability and avoiding disruptions in public administration. The orders effectively stay the Court of Appeal's declaration that nullified the Finance Act, allowing the government to continue its operations while the legal battles plays out. Furthermore, the court acknowledged the importance of public interest, stating that granting the Treasury's request would promote stability in both the national budget and the allocation of funds while the appeal progresses. The Supreme Court noted in its ruling, the conservatory orders are necessary to avoid potential operational disruptions in government activities. We are not convinced that the consequence of declaring the entire Finance Act as unconstitutional would be reversible should the appeal before us be successful. The consolidated appeals, which include petitions E031, E032 and E033 of 2024, are scheduled for an expedited hearing in September 2024. The outcome of the hearing is eagerly anticipated, as it will have far-reaching consequences for Kenya's legislative process and the future of Finance Act 2023, considering new taxes introduced by the Act include a 5% withholding tax on digital content monetization, a capital gains tax on transfer of shares, 16% VAT on petrol, kerosene, aviation and jet fuel, housing levy, among others. David Kagina, K24, Nairobi.